Good morning to you all. Thank you for joining us. In today's webinar, we'll be discussing the legal landscape of flavored commercial tobacco products. I'm Marissa Katz, and I'll be presenting today with my colleague Willow Anderson. We provide legal technical assistance on commercial tobacco control issues, including flavored tobacco product regulation here at the Public Health Law Center. For those unfamiliar with our organization, we're a 501c3 nonprofit housed at the Mitchell-Hamlin School of Law in St. Paul, Minnesota, which is located within the traditional homelands of the Dakota people in an area known as the Bdote region. We appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which the law school sits. The Public Health Law Center is comprised of 3 programs: commercial tobacco control, healthy eating and active living, and climate justice, all of which include attorneys, policy analysts, and support staff working together to improve public health through the power of law. We offer free legal technical assistance to communities, public health advocates, and other partners. We also publish on current issues pertaining to all 3 of our program areas, as well as offer trainings and webinars. We do have some limits on our work. We do not provide direct client representation, give legal advice, or lobby elected officials. Health equity is at the center of all of our work. When we're helping to craft various types of public health policies, we remember that people are differently situated, and applying the same policy approach across the board may have different effects and outcomes for different groups of people. Our work is also done with mindfulness of several factors that influence public health, including housing, education, the environment, and a variety of other social determinants, meaning we never want to offer policy solutions that would cause someone to lose their job or their housing and then subsequently impact their health. Policies in the tobacco control context should instead seek to balance the goal of protecting the public from the harms of commercial tobacco with knowledge that punitive measures against those who use these products are unlikely to help them in their struggle with nicotine addiction. And finally, before we dive into today's topic, we want to acknowledge the difference between traditional and commercial tobacco. Throughout this presentation, we'll refer to the impacts of tobacco, but it's important to clarify that we're talking specifically about industrial scale commercial tobacco production and not traditional tobacco, as it is used religiously, medicinally, and ceremoniously in many different cultures. There are 2 resources linked on this slide, which provides in-depth information about traditional tobacco if you'd like to learn more. So today we're going to kick off the discussion on flavored tobacco products by first providing a general overview on what these products are, and then I'll talk about federal regulation over the past 15 years and the FDA's continued delay in implementing the menthol and cigar rules. And then we'll talk about what states and localities can do in the absence of federal regulation. And then we'll discuss how the industry has challenged these prohibitions in court, largely without success. And then we'll address, for those jurisdictions that haven't passed laws with flavored product restrictions, what they can learn from those that have successfully implemented and defended policies in court. And then we'll wrap up in our remaining time to address any questions or comments that you all have on this topic. So for the uninitiated, what are flavored tobacco products and why do they even exist? When we talk about flavored tobacco products, we're referring to the universe of products out there that are produced, manufactured, and distributed by the tobacco industry. And this includes primarily flavored e-cigarettes, menthol cigarettes, and flavored cigars. There's also flavored smokeless tobacco products like snus. And then the latest products that have unfortunately increased in popularity among youth are synthetic oral nicotine pouches, products like Zyn. And the tobacco industry has sold flavored tobacco products in the market for many decades. And the reason is simple. Flavored tobacco products have and continue to be a very profitable revenue stream for them. And this is because flavored products mask the harshness of tobacco and improve the taste, which in turn makes it easier to initiate new smokers. And not to sound too grim, but bringing in new smokers and getting them addicted to these products is essential for an industry that, to maintain its profits, must replace lifetime smokers who have died of cancer and other disease we have known for quite some time are linked to tobacco product use. The tobacco industry also has a long track record of targeting certain demographics with flavored tobacco products, particularly youth. Research has shown that flavored products increase initiation among all populations, but especially with kids. Research has also shown that most smokers try cigarettes or e-cigarettes before they turn 18, and that most teens start with flavored tobacco products. As for menthol in particular, it's important to have a bit of background on these particular products because they've had such an outsized role in our society and have caused a lot of damage. Menthol's cooling properties, like other flavored products, mask the harshness of tobacco and the irritation that results from nicotine use. Again, evidence tells us that menthol enhances the addictiveness of cigarettes, both by increasing the likelihood of nicotine addiction in youth and by making quitting among adult smokers more difficult. It's also important to note that the tobacco industry has specifically targeted its sales of menthol cigarettes to historically marginalized populations. As a result, menthols are used at disproportionately higher rates by racial and ethnic minority populations. In particular, African American smokers, of whom almost 85% smoke menthols. Of Latino smokers, 46.9% use menthol. For Asian Americans, 38% of those smokers use menthol, as compared to white smokers, in which they're under 30% use menthol. With other groups, over 70% of LGBTQ smokers use menthols. At least half of all teen smokers use menthol products, including 70% of African American teens, and more than 50% of teens of Latino descent. Menthol product use is also prevalent among non-minority youth, as well as with low-income populations. And it's because of industry targeting that we know that tobacco-related health disparities, including chronic disease and death, are then exacerbated among minority populations as a result. We also know most recently from the Centers for Disease Control and Prevention's 2023 National Youth Tobacco Survey that e-cigarette use among youth remains at very high levels. About 1 in 10 middle and high school students said they recently used a tobacco product, which translates into 2.8 million kids nationwide. And of those, more than 2.1 million youth currently use e-cigarettes. Of those who use e-cigarettes, 90% of students who vape reported using flavors with fruit and candy at the top of the list. The most popular brands among youth are ones you've seen on market shelves, including well-known brands such as Elf Bar, Vuse, and Juul, to name a few. And some of these flavored products are clearly designed to attract youth, with flavors like blue cotton candy, dragon fruit banana berry, root beer float, and so on. And it's important to know that flavored products are not only popular, but they are packed with nicotine. You can see how brands like these are appealing to youth with the use of bright colors, with fruit flavors and candy images. And I want to thank the Minnesota-based Tobacco Free Alliance for doing the math here to illustrate the really compelling comparison between nicotine content levels in e-cigarette products versus combustible cigarette products. The big picture here is that disposable vape products, which contain higher nicotine salt levels than other products, have been available the past few years and continue to flood the market. On average, it takes several days, not weeks, to go through one of these disposable vapes. So these are very addictive, very harmful products. So the question is how are these and other flavored products even still available on the market? Let's start with what's happened at the federal level. Congress passed the Family Smoking Prevention and Tobacco Control Act, commonly known as the TCA, which was signed into law by President Obama back in 2009. This landmark law prohibited cigarettes from containing any characterizing flavor, including candy, fruit, and alcohol flavors. And the law is the reason why you don't see watermelon flavored Marlboros or cherry flavored Camel Lights in the marketplace. However, thanks to the tobacco industry lobby and the huge role menthol plays in product sales, the law exempted both tobacco and menthol flavors. And the law did not extend to e-cigarettes and other non-cigarette tobacco products. The TCA, as sort of a congressional acknowledgement of the public health void left by these exemptions, created and directed the Tobacco Products Scientific Advisory Committee to study the issue of menthol use in cigarettes on the public health, including such use among children and certain racial and ethnic minorities. After this initial study was completed, the advisory committee issued a report documenting its findings in July of 2011, which concluded, unsurprisingly, that removing menthol cigarettes from the marketplace would benefit public health. At this point, rather than acting promptly to protect public health by prohibiting menthol as a characterizing flavor, the FDA instead announced it would conduct its own independent study on menthol cigarettes. And in July of 2013, the FDA released a report that essentially confirmed the Scientific Advisory Committee's findings and conclusions, which is that menthol cigarettes not only pose a public health risk, but also that public health risk exceeds the risk posed by non-menthol cigarettes. So the FDA then issued an advance notice of proposed rulemaking. It was at this time that 174,000 public comments were recorded on the docket. And this was in addition to the already thousands of pages of menthol research gathered by the FDA itself and the advisory committee and public health groups. And still no rule was implemented despite these reports. In 2016, the FDA did finally issue a regulation asserting jurisdiction over non-cigarette tobacco products. And this is more commonly known as the deeming rule. And it's important because it meant the FDA would now oversee the regulation of e-cigarettes. However, at that time, the White House Office of Management and Budget ended up removing the flavor prohibition provision that the FDA had originally had in its deeming rule. And in 2017, the FDA announced a comprehensive regulatory plan for tobacco products that was intended to prioritize restrictions on flavors that are attractive to youth, including menthol. And in January of 2020, the FDA did order the removal of some flavored cartridge-based e-cigarette pods from the market. But it didn't make a huge difference since this restriction ultimately led to an increase in the sales of self-contained disposable e-cigarettes and why we still see flavored products everywhere. So sales of tobacco and menthol flavored cartridge-based e-cigarettes continue, as do the sales of refillable flavored e-cigarette products. So we're still grappling with a lot of bad youth alluring flavored products out there on market shelves. So it's against the backdrop of this regulatory inaction on the part of the FDA that citizen petitions began to be filed by public health organizations and advocacy groups to try to push the federal government into action. And under the Administrative Procedures Act, federal agencies must give interested parties the right to petition for either the issuance, amendment, or repeal of any federal rule. And this is known as a citizen petition or a rulemaking petition. And in theory, the APA petition mechanism is supposed to be an efficient means for an individual or other stakeholder to call on a federal agency to take a particular action. And in this case, the citizen petitions filed starting in 2013 by the Public Health Law Center was for the FDA to issue two rules, the menthol rule and the cigar rule. And both are intended to finally close the major loophole left open since the TCA was passed back in 2009 by designating menthol as a prohibited characterizing flavor, as well as banning all flavored cigar and cigarillo products. So this slide just illustrates a rough chronology of attempts by interested public health organizations, including Public Health Law Center, that have spent more than a decade trying to get the FDA to act on both the menthol and cigar rules. And in 2021, the FDA announced it would remove menthol from cigarettes and all flavors from cigars and cigarillos. However, it still is not committed to a specific deadline as to when this will happen. It's been 2 years since the public comment period ended on these rules, and most recently, the African American Tobacco Control Leadership Council led the charge again in filing another citizen petition on April 2nd of this year. So we'll see how this litigation plays out. But just a few weeks following the filing of that lawsuit, the Biden administration announced on April 26th that it is again delaying the release of the menthol cigarette rule. Health and Human Services Secretary Becerra issued a scant 47-word statement. You can see here on the slide, indicating the administration's clear intent to not finalize this rule anytime soon. So here we are 15 years after the passing of the TCA, and despite the mountain of irrefutable scientific evidence demonstrating that removing these products from the market would save tens of thousands of lives each year, not to mention reducing youth initiation and increasing cessation, it's really unacceptable that these rules haven't been adopted yet. And ultimately, what this federal inaction underscores is how important it is for state and local governments to work towards protecting public health and pushing back against big tobacco by getting these products off shelves. And importantly, the TCA does preserve state and local governments' authority to enact laws that prohibit the sale of tobacco products. So states may enact their own laws related to product sales. However, states cannot regulate what's known as tobacco product standards, meaning they can't regulate the characteristics of a tobacco product. And it's the tobacco product standards provision that is often argued by industry when challenging state or local sales prohibitions on flavored products. But most courts have rejected those arguments since flavor prohibitions are directly related to the sales prohibitions preservation clause in the TCA. And it's not just flavor prohibitions. The case law is also pretty settled in that states do have the authority as well to regulate where and how products are sold in their jurisdictions, including regulating public use, clean indoor air laws, tobacco retail licensing laws, taxing and pricing, and internet sales, just to name a few. As for local units of government, it's really cities and counties that play such a critical role in bringing about effective public health outcomes. However, they can't do this without the authority to set their own public health agendas, and the ability for them to do so will vary depending on where they're located. For home rule chartered municipalities, cities and counties usually enjoy more extensive autonomous powers to undertake a range of public health initiatives, like tobacco product sales restrictions. On the other hand, municipalities that are located in Dillon's rule states, where there are express restrictions on what municipalities can or can't do, those are usually contained either in the state constitution itself or codified in state law. And these cities and counties, this is because they're deemed to be extensions of the state rather than more autonomous entities with broad public health authority. So they're going to be much more limited in enacting local public health laws. So what are the states and municipalities out there that can prohibit or otherwise restrict flavored tobacco products? And here I just want to bring your attention to the Public Health Law Center's resource on this very topic, which was updated last month. And it provides an extensive review of jurisdictions across the country that have enacted some type of sales restriction on flavored tobacco products. It's organized into different charts based on the type of flavored product restriction, as well as by state, so you can see the range of policies in place. I encourage everyone to check this resource out when you can and see what sorts of policies are in place in your state or locality. But to give you an overview of the states around the country that have flavored product regulations, there are currently 8 states with restrictions. As you can see, they vary with product type. For instance, Maine does not prohibit menthol and only covers non-premium flavored cigars, whereas New York, New Jersey, and Rhode Island all have menthol prohibitions, as well as prohibitions on all flavored e-cigarette sales. Massachusetts became the first state to prohibit the sale of flavored tobacco products, including flavored e-cigarettes and menthols. So it's pretty comprehensive there. And in California, voters upheld that state's law prohibiting the sale of flavored products when it faced an industry-backed ballot initiative. At the local level, more than 375 municipalities have enacted ordinances restricting the sale of flavored tobacco products. There are 26 cities and counties, all of which are in California, except for the city of Bloomington in our home state of Minnesota, that do have comprehensive ordinances that are jurisdiction-wide. They prohibit menthol, they prohibit all tobacco products, and they don't allow for any retailer exceptions. The vast majority, though, are less comprehensive and vary widely, but are still really good first steps. Some prohibit only menthol flavored products, whereas others cover multiple tobacco products, including retailer exceptions such as licensed smoking bars or specialty tobacco stores. Or some jurisdictions may have product exemptions, usually with products like hookah, premium cigars, pipe tobacco, and the like. So there's not uniformity among the jurisdictions, but importantly, these are places where proactive steps are being taken to try to limit the availability of these harmful products in communities across the country. And a few highlights to mention, back in 2013, Chicago became the first city in the US to restrict the sale of all flavored tobacco products, including menthol. And likewise in 2017, the San Francisco Board of Supervisors unanimously passed an ordinance prohibiting the sale of menthol and all flavored tobacco products. Both of these highlight case studies and are helpful resources for jurisdictions currently considering whether to adopt flavored tobacco product restrictions. These case studies are helpful with respect to learning from those cities' experiences, so ranging from how to prioritize community engagement to thoughtfully considering how to implement a new law, which includes robust enforcement, while also factoring in social justice issues surrounding the effects of menthol and other flavored products that we know have been disproportionately felt by youth and historically marginalized communities. So as you can see, there's clearly momentum at the state and especially at the local level in which the public health threat of these products is well known and action has been taken. Of course, big tobacco is not sitting idly by without a fight. And the tobacco industry has filed multiple lawsuits challenging these prohibitions, arguing a variety of legal claims, which Willow will speak to. But the takeaway here is that flavored tobacco restrictions have withstood legal challenges across the United States. As I mentioned, Massachusetts was the first state to implement a statewide flavor ban in 2020, and the law survived industry challenge when it was upheld by that state's Supreme Court in 2021. Likewise, in California, their own statewide ban that took effect in 2023 survived industry challenge in the R.J. Reynolds versus Bonta litigation, including the U.S. Supreme Court declining to hear the case and therefore impliedly upholding the authority of states to legislate matters of public health. That said, it's still important that public health advocates understand all of these legal challenges brought against state and local restrictions on flavored tobacco products, so that jurisdictions looking to enact such laws do so in a way that's crafted carefully and with strong public health justifications so that these policies are able to withstand legal attacks by big tobacco. And with that, I will turn it over to Willow, who will talk more about those claims.
Thanks, Marissa. That was great. I'm going to highlight a few of the big flavor cases and then speak more generally, synthesizing the body of constitutional challenge we've seen over the last decade or so on flavors. I'll wrap it up with some lessons learned and practice tips in crafting a legally defensible policy. And finally, we want to save some time for questions at the end. Let's pick up right where Marissa left off with R.J. Reynolds versus Bonta, probably the biggest and most recent case dealing with flavors. What happened there? R.J. Reynolds, who owns Camel, Winston, Salem, and Cool, to name a few, sued the state of California, represented by Bob Bonta, the California Attorney General. And later, in support of the flavor restriction, we here at the Public Health Law Center filed an amicus brief or friend of the court brief, along with other public health groups to assist the court in looking at the issues through a public health lens. And if you're really interested in the full body of public health case law here, I encourage you to take a look at the cases cited in that brief, which is posted on our website under the litigation tracker. Here are the key facts. California passed Senate Bill 793, which prohibited the sale of flavored tobacco products, including menthol. It was clear from the record that the legislative intent was to reduce tobacco use among youth and other targeted populations. And R.J. Reynolds, along with other retailers, filed a lawsuit seeking to block the enforcement of SB 793. They argued that state law was preempted by federal law, specifically the Tobacco Control Act, which grants the FDA authority to regulate the manufacturing, marketing, and distribution of tobacco products. So the issue the court needed to determine was whether the TCA preempted California's SB 793. For context, here's a quick primer on preemption. It can occur in several ways. You've got express preemption. That's when a federal statute explicitly states that federal law takes precedence over state law. Implied preemption is when state law conflicts with federal law or when federal regulation is so comprehensive that it leaves no room for state regulation. And then finally, conflict preemption that arises when it's impossible to carry out both state and federal laws. In this case, RJR argued both express and implied preemption under the TCA, claiming that federal law established a comprehensive regulatory scheme that left no room for state regulation, and that the FDA had exclusive authority over tobacco product standards, including flavors. And as you all know by now, the court ruled in favor of the state of California, finding that the Tobacco Control Act did not expressly preempt state laws regarding the sale of tobacco products. Also importantly, the court recognized that states have broad authority to regulate matters of public health, including the sale of products within its borders. RJR, of course, appealed, but the decision was affirmed. RJR also asked the U.S. Supreme Court to review it, but the court denied cert or declined hearing the case. So the statewide flavor ban is fully in effect in California. This was a similar claim that the company brought versus a city a few years earlier, which was finally decided last year. Here are the facts of that case. Edina, Minnesota passed an ordinance in June 2020 banning the sale of all flavored tobacco products. In federal court, RJR argued that Edina's law was expressly and impliedly preempted by the Federal Tobacco Control Act. Yet the Eighth Circuit found that the ordinance did not conflict with federal law, emphasizing that local regulations on sales are not precluded by the TCA. On appeal, the Eighth Circuit upheld the decision, and RJR did not ask the Supreme Court for review. Here again, the Public Health Law Center, along with 23 other public health organizations, supported the city of Edina with a brief highlighting the issues under a public health law lens. And if we're talking about flavors litigation, we need to at least mention the spate of lawsuits filed by states versus Juul. All but one state settled before trial. In 2021, the state of Minnesota filed a lawsuit against Juul and Altria, its parent company, and it went to trial in March 2023. This isn't a flavors lawsuit per se, but it's another way to get at these products, which are all virtually flavored products. The states, including Minnesota, alleged that Juul had committed consumer fraud, deceptive trade practices, false advertising, public nuisance, and negligence. I attended part of this trial, and one of the most remarkable things I heard was the perspective of the companies. During opening statements, the attorney for Juul argued that they shouldn't be held liable because the company's primary goal was to switch adult combustible smokers to vapors, and that the youth who picked up this addiction for the first time were leakage. That was the word he used, leakage. And that's a shocking admission from the company's own attorneys. Aside from the fact that they actually were marketing to youth, referring to the kids who got addicted to their products as leakage shows a callous disregard for the harm caused to these young people. The other part of their defense was that Big Tobacco had already paid enough through the 1998 Master Settlement Agreement, and that the legislature was to blame. Juul and Altria argued that the legislature could have and should have done more to protect the youth from their own products. Their attempt to shift blame to the legislature was appalling, and the state made a strong case that it was their aggressive flavored marketing tactics, not the legislature, that fueled the youth vaping epidemic. The trial was about 2 weeks long. After closing arguments, the parties settled, and Minnesota's $60.5 million settlement with Juul and Altria was the largest per capita of the 48 states and territories that settled. If you want to see how much your state settled for, check out our website, which has an interactive map describing the terms of settlement within various states. As part of the deal in Minnesota and many other states, Juul agreed not to sell flavored products, but restricting only Juul flavored products isn't enough, showing why a comprehensive approach with state and local units of government is still needed. So those are a few of the big, most recent cases, but we've seen a lot of lawsuits from the industry around the country. And in every case, I know the flavors restriction has been upheld. So moving now more generally, and for your continuing legal education credit, let's look at the constitutional challenges. These are important to keep in mind as you're drafting flavors restrictions so that they remain legally defensible. Here's a closer look. We already talked a little bit about preemption, so I won't go into much more detail here, other than to say it's an oldie but a goodie. The industry really likes these arguments, but more than that, they like to run the theme on these arguments. And what I mean by that is they like to say that lower levels of government can't regulate, but then when the FDA tries to do something, it says that they can't do it either. So courts have been clear that sales restrictions are not preempted by federal government. Big Tobacco has argued flavor bans violate the Commerce Clause by overstepping the boundaries of state power by regulating both interstate and intrastate commerce. However, here again, courts have weighed these constitutional challenges, and they side on the side of public health interests, and they've won every time on that. Tobacco companies argue that flavored tobacco bans infringe on their commercial speech rights. They claim sales are lawful and marketing is not misleading. And while governments cite health interests, companies challenge this and say bans aren't the least restrictive option or directly advance youth protection. Courts balance public health benefits against the ban's impact on commercial speech. Equal protection challenges argue flavored tobacco bans unfairly discriminate between products or businesses without valid justification. Key claims are one, that ban treats similar products differently. For example, banning some flavored products but not the others. Also that there's no rational basis for this distinction, as all tobacco products pose health risks. And third, though unlikely for commercial bans, heightened scrutiny could apply if a suspect classification or fundamental right is involved. The focus is whether the law violates the principle of treating like situations unlike under the law. Vagueness challenges argue terms like characterizing flavor are unconstitutionally unclear, leading to arbitrary enforcement. Overbreadth challenges claim bans prohibit more than necessary to curb youth use by restricting adult access. However, courts have generally rejected these claims, finding that terminology sufficiently clear and the bans appropriately tailored to the public health interest. Generally speaking, procedural due process requires that the government must give notice and an opportunity to be heard. But in terms of flavors, tobacco companies have argued that vague terms like characterizing flavors don't provide clear notice of what's prohibited. There's also a substantive due process requirement. And here we see tobacco companies have argued that bans infringe on lawful adult choices beyond what's needed to curb youth appeal. Nevertheless, courts tend to uphold flavor bans as reasonable health measures that don't deprive companies of due process rights. The takings clause of the Fifth Amendment prohibits the government taking from private property for public use without just compensation. And this clause has been invoked in various cases challenging flavored tobacco bans. What we have seen, both in the scale of RJR Tobacco, also National Association of Tobacco Outlets, and then we've seen a number of vape and tobacco shops locally use this argument, but they've been unsuccessful. And sometimes what we've seen is cities strike a compromise to not implement a ban right away, but to allow some more time for the store to sell its product. So here again, courts don't generally find flavored tobacco bans to be a takings under the Fifth Amendment if the bans are justified by public health and do not completely destroy property value. How can we do this better? I wanted to highlight lessons learned and legal challenges from states that have implemented flavored tobacco bans. As public health law lawyers, we consider these points for effective implementation. So we've done sort of a canvas and working with our colleagues within the Public Health Law Center who are helping states that have implemented these bans, and other professionals. We've been in close conversation about what's gone well and what we could do better. The first piece, enforcement. Ensure adequate funding and mechanisms to monitor compliance. That's a big one, maybe the biggest one. The second one, notice and lead time. Provide businesses with sufficient notice and time to adjust, preventing immediate enforcement issues like those faced in California. Number three, notification processes. One tip that we've had that's been, I think, quite useful is utilizing state tax authority lists to notify businesses about the ban. Four, forfeiture processes. Develop clear guidance for handling and forfeiting excess inventory. Five, public health department. Engaging the public health department for health checks and inspections has been a useful lesson learned from a lot of the jurisdictions that we've heard from. Six, safety concerns. Address safety hazards from aging, leaking products, and transmission of hazardous materials. Seven, attractive nuisances. Prevent children's access to excess inventory that may be hazardous. Eight, evaluation and monitoring. Implement systems to monitor the ban's impact and adjust as necessary. Nine, continual adaptation. Regularly review and update the ban to cover emerging products and loopholes. 10, collaboration, engage stakeholders to address concerns and ensure smooth implementation. 11, raise awareness about the dangers of flavored nicotine products and reasons for the ban. 10, lessons from others, so study other jurisdictions' experiences to avoid pitfalls and improve implementation. Bottom line, you may be a city attorney out there. You may even be representing a jurisdiction that has the political will to do this. But gosh, that seems like a lot of work and potential risk to opening up yourself to litigation by this industry. And you may be wondering, is investment in this policy worth it? Meaning, are flavors restrictions worth it? And to that we say yes, the numbers are undeniable. If we're going to draw the line on the vaping epidemic that is intruding our classrooms and schoolyards, then flavors is where it's at. On this slide are some stats from the campaign for tobacco-free kids. And Marissa did a good job of making the case early on in her portion of the presentation as well. And we want you to know that the Public Health Law Center and other groups are here to help you defend these policies in your jurisdiction. And for those who have done that, we say thank you. And for those who are perhaps interested in learning more, our door is always open here at the Public Health Law Center, and we would be pleased to talk with you. Here are some relevant resources prepared by the Public Health Law Center. Feel free to check them out on our website. And here's how you can contact us. Thank you for attending. And we do have some time to answer questions.
All right. Thanks, Willow. And we're just looking at the questions posted, and we'll go through as many as we can. I think just let's see. There's one here that asks whether there are any flavored cannabis products that are covered under SB 793, which is California's law, or any other laws. Willow, do you want to answer that?
Yeah, no, the flavored cannabis is not included in SB 793 or any other flavors bans as far as I'm aware.
Okay, great. And then, so here's one. It's a great question. It's asking how can rural projects who have not passed policies yet, like a TRL or flavor ban, incorporate these best practices into their TRL, and otherwise plan for best practices regarding implementation and enforcement with very limited resources. And I can take this one. It's a really, really great question and such an important point to make, because we know that rural communities suffer the most tobacco-related health harms, and it's difficult to overcome those health disparities because of either weak or non-existent local tobacco control policies, which is, usually just attributed to a lack of resources. One avenue is to establish tobacco retailer licensing through licensing fees. So you're not placing a financial burden on already limited local resources. We know as well that the most prevalent tobacco retailers in rural areas tend to be convenience stores, grocery stores, discount outlets, those types of places. So focusing on these types of retailers could help reduce tobacco retailer density by restricting the types of businesses that sell tobacco products, like, for example, pharmacies. And so putting into an ordinance that pharmacies are prohibited from selling tobacco products and similar places. Rural communities that want to limit youth access to flavored tobacco products, including vapes, of course, could restrict sales to specialty shops, such as smoke shops that only permit in-person sales for people who are 21 years and older. Another option is to regulate the location of tobacco retailers by creating buffer zones around places like healthcare facilities, schools, and other youth-oriented places like parks and playgrounds. But yes, ultimately, rural communities, face their own unique challenges, and so taking a more step-by-step or incremental approach as resources permit may be the way to go.
Yeah. Yeah, thanks, Marissa. We have another question about are dual use products such as vapes with cannabis or illicit drugs covered as well? I think when that question came in, we were talking about the California ban. No, dual use products are not. So the new California law, it says it's a tobacco retailer or any of the tobacco retailer's agents or employees shall not sell, offer for sale, or possess with the intent to sell a flavored tobacco product. So it doesn't include dual use products unless those are products that are used for tobacco. There's another question here about tobacco product waste. We'll try to get here too. It says, can you point to an example of a state or local flavor prohibition law that includes language addressing the safety and tobacco product waste concerns? I'm not yet aware of one, and while it's very important, I feel like it adds weight to the flavor ban bill. We definitely need manufacturer responsibility for all commercial tobacco wastes. Vermont just passed something, and I can send that to you actually, to the caller. I can pass that along, or maybe if there are other Vermont listeners on the line, you can go ahead and share that bill. That was not a flavor ban bill. That was a manufacturer responsibility bill, and it included vapes. So still a lot of questions about enforcement and penalties with that law, but what a great first step Vermont has taken on that piece. But otherwise, no. As far as I'm aware, we don't have an example of state or local flavor bans that also include tobacco product waste. But I think it's always important to include that in our conversation.
Yeah, thanks, Willow. And that is an exciting development out of Vermont. So people should check that out. There's another one. I think we have time for just one last question, which is asking about flavors and whether there's any documentation that's been developed, that the industry has developed certain flavors to target certain cultural groups. Listing as an example flavors such as dulce de leche that may be more popular among Latinos. And that's a great question. And I think, it highlights like the history of the tobacco industry and their tactics. And we know full well since the 1950s that they've deliberately targeted the African-American population with menthol. Of course, menthol has had a huge reach across all sorts of groups, but in particular, it's caused a great deal of harm to the African-American community. And that was evidenced in tobacco industry documents that were disclosed during the litigation back in the 90s. And then also with USA versus Philip Morris as well. And, so I think most recently, I will say that the University of California, San Francisco is the main depository of tobacco document information that's resulted because of all this litigation. And that includes the Juul settlements as well. So, they're starting to now collect all the industry documents for e-cigarette products and how. And so I think it's worth, my guess is that it is probably documented that to the example given, like dulce de leche, that there's probably industry documentation showing that, they are very deliberately targeting certain groups of people with certain types of flavors. So it's a massive database, but that evidence is most likely there as most recently as when we've seen the rise in vape products. So yeah, and we are at time, I see. Thank you all. We didn't get to every question, so we will do our best to get in touch with the people asking them and through email. You know how to contact us as well. And thank you for your time today. We hope it was helpful, and have a great rest of your day.
Thanks a lot.